This is a question for Professor Bladdock. Professor Bray noted in his testimony the concern about extreme foreign shopping, especially in single judge districts. So I think you're familiar with a bill that I had introduced, which I intend to introduce once again, about the Stop Judge Shopping Act. It was not motivated by a concern about nationwide injunctions, but here we are. I think it has relevance. And I'm wondering, Professor, do you think that parties would seek and receive fewer nationwide injunctions if they were not able to judge or foreign shop for favorable outcomes? That's happened in the Texas mifepristone case.
I think there's no question, Senator. I mean, I think the data, such as it is, shows that there was a higher success rate when parties sought nationwide relief during the Biden administration in single judge divisions than when they filed in courts that had random assignment to more than 3 judges. And so, that's a small data set, and I don't want to overstate it. But yes, I mean, there's almost no conceivable way in which it wouldn't be smaller.
So that would be, in my view, it would be a fair, I suppose, way of addressing the concern over nationwide injunctions.
So, I mean, I would say, if I might, 2 things. The first is that I think distributing assignments would at least mitigate the allure of nationwide injunctions in cases in which the median judge might not issue it. I mean, Professor Bray referred before in the birthright citizenship case to his confidence that any judge would block this order. The issue is not those cases. The issue is cases where the identity of the judge might be dispositive. So that's piece one.
Especially in single judge districts. This is again for you and perhaps Professor Bray. I'm trying to understand the practical effect of Chair Grassley's proposed legislation wherein where you limit the relief that a court can grant to only the parties before the court. So I would like to know how, in a case like the mifepristone decision, how the relief granted would apply only to the parties before the court.
So, I mean, I think it's even more powerfully illustrated, Senator, in the birthright citizenship cases, because in a context in which you had, say, individual non-citizen parents, or even, a group of non-citizen plaintiffs, say, in Northern California, seeking to block the birthright citizenship policy, an injunction that only ran to them would be of no benefit to non-citizen parents in Southern California, in Oregon, or anywhere else in the country. And so you would need litigation, on a retail nationwide basis to ensure that that these parents could have confidence that when their children are born in the United States, they're born citizens.
So you're saying that multiple lawsuits must be filed to obtain the relief if we're going to go with what is in Senator Grassley's bill, that the relief will only be granted to the parties before it. There are certain issues that certain cases where it wouldn't make sense.
Well, and so Senator,
unless,
and this goes back to the chairman's opening statement, unless you were in the same bill to reinvigorate nationwide class actions, unless you were to effectively trade nationwide injunctions for a reinvigorated nationwide class action where you'd be able to show that all non-citizen parents who have a childbearing age, right, are affected by this order.
Professor Bray, do you want to
I would love
weigh
to.
in?
Yes, I would love to. Thank you, Senator. So I think the mifepristone case is a great example. You couldn't really have an injunction to protect the plaintiff's interests there because the plaintiffs didn't have standing. But what the case shows is...
Well, let's say that the plaintiffs did have standing.
What the case shows is the lack of fit in so many of these cases with universal injunctions between tenuous, narrow standing claims, including DAPA, the original 2015 one, the tenuous, narrow standing claims, and massive universal relief.
Okay,
and that's not the way
I'm saying that, let's say that the standing issue was overcome, and then you have a court that says what the FDA did not comport with the APA, and can that court limit that holding just to the plaintiffs before him or her?
Well, in that sort of case, the court should adjust its remedy to whatever the injury is. So you'd have to have a real specific injury to then tailor the injunction to it. And in a case where you don't have one, you can't really have an injunction tailored to the remedy. I mean, tailored to the injury. So we'd have to hypothesize an injury and then hypothesize an injunction that matched it.
Thank you,
I realize
Professor
my
Bray.
time is up, but my point is that I think there are some concerns about the approach that the chairman is taking in his bill.
Thank you,
Thank you.
Senator Hirono. Senator Hawley.
Thank you very much, Madam Chair.